Thank you so much, Ms. Wells. I will call this committee to order on Thursday, whatever day it is, March 24th. This is the Senate Judiciary Committee. Would the esteemed secretary please take the roll?
Vice Chair Cannizzaro.
Please mark Vice Chair Cannizzaro present when she gets here, and as always, I'll try to make a note of it.
Senator Orenshaw.
Here.
Senator Harris. Senator
Senator
Settlemyre.
Harris, excused.
Here.
Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Here. And if you could please mark Senator Harris as excused. We also have with us today Mr. Pat Guinan from the Legislative Council Bureau. He is our committee analyst. Our committee counsel, Nick Anthony, remains available to us to answer questions, though he's not here in live time. And today we only have one bill presentation, and then we will have a couple of BDR introductions to do or to vote on at the end of the meeting. But for now, I would like to turn it over to our friend and colleague, Senator Julia Ratty, who joins us today. Not a member of our committee, so it's a special pleasure to have her here presenting SB 218 to us, and I will now open the hearing.
Try that again. Thank you, Chair Scheibel. My name is Julia Ratty, and I am State Senator representing Senate District 13, which is the middle of Reno and Sparks. As always, I am pleased to join the Senate Committee on the Judiciary, which I am grateful to not be a member of because I try to not end up in this committee too often unless I can bring today. I am excited to have been able to bring legal counsel. So I have with me today Jim Berthold, who is the directing attorney from the Consumer Rights Project for the Legal Aid Center of Southern Nevada. We bring to you today Senate Bill 218, which is a bill that seeks to address the challenges that are facing some tenants when it comes to working with their landlords to get to a reasonable place to be able to maintain housing. I think you all will remember that in last session, we passed Senate Bill 151, which included some modest protections for tenants. This is a significant issue because we're talking about Maslow's hierarchy of needs. Every individual to thrive needs food, shelter, clothing. And this bill really gets to the heart of the issue of can somebody who is a renter maintain stable housing? In response to Senate Bill 151, there were a subset of landlords that responded in a way that I would describe as, and I want to be very clear here that the vast majority of landlords are good players, that they work with their tenants, that they're interested in maintaining a professional relationship, and that they don't take advantage of the power dynamic that they have, which is that they have control over somebody's housing. But unfortunately, there's a small subset of landlords who have an oversized impact on the tenants who are in a quite vulnerable position. And so what happened is in the last legislative session, after SB 151 passed, one of the things that SB 151 did was it capped late fees. We had seen some really egregious practices when it came to piling late fee on late fee in order to move what some landlords felt were undesirable tenants along. So we capped late fees. And in response to that, this subset of landlords tried to figure out how they could fleece their tenants for money in other ways. And so some of the things that happened is there was a large property owner in Las Vegas that sent out a notice to 5,600 tenants, unilaterally changing.
Do me a favor and close the door, please. Oh, sorry.
That's okay, Senator Pickard. Unilaterally, I was just making my most important point too. So there were some. I
am so sorry.
It's okay, Senator. So there are, so again, there was a landlord that unilaterally tried to change the conditions of every tenant who was under a lease. One of the most significant things that we saw is that there were landlords that had had a grace period for years on their properties. And these landlords had tenants that were senior citizens. And if you are above a certain age and you are receiving your Social Security check, you know that that Social Security check arrives like clockwork on the third day of the month. And these landlords had worked with those tenants. They had not put in late fees for a senior citizen or a person with a disability who was paying with their Social Security check. And all of a sudden, after the passage of Senate Bill 151, late fees were being applied to tenants that had regularly paid their rent on time. So what this bill seeks to do is to do some cleanup. As always, whenever we pass any legislation, there's some things that we need to get right. But what it really seeks to do is codify the best practice of providing tenants with a 3-day grace period. This will, in one legislative action, take care of all of those senior citizens and people with disabilities who receive their Social Security check on the 3rd and pay on time, so that they won't have an extra $25 or $50 late fee on their rent just for no reason. It adds some clarifying detail on security deposits. Another thing that we saw is that some landlords, and again, it's a small subset of not necessarily our best actors, who became more aggressive about retaining a portion of the security deposits. And I'll pause here to say that I rent an apartment in Carson City during the legislative session. We rented a duplex last legislative session. There were tenants that we were familiar with on both sides. In both cases, the landlord withheld a significant portion of the security deposit with no real justification. For the tenants that were next door to us, they withheld 100% of the deposit for things like the cleaning lady that the landlord contracted with spilled some bleach on the carpet, and the tenant got charged for that, as an example. So we need greater clarity for when a landlord can withhold part of the security deposit and when they cannot. That needs to be strengthened in our laws. And there needs to be an expedited process for a tenant who is operating in good faith and is doing everything right, because right now, while somebody can be evicted within 10 days, they often don't get their security deposit back for up to 30. And that gap in time between that eviction and when they get their security deposit means that they don't have the resources necessary to pay the security deposit and first month rent on their next property. So we really do need to figure out, from a timing perspective, how that tenant who has done well can rapidly get their security deposit back, and how we can make sure that predatory landlords aren't withholding a security deposit in a situation, again, where they have significantly more power and influence than that tenant in the same contract. And then finally, we saw a slew of fees that had never been seen before. And my email address I just kept hearing from many of my constituents. There was a particular landlord in Northern Nevada who decided to dive in on the deep end on this one. Light bulb fees, dishwasher fees, cleaning fees that hadn't existed before. You name it, they came up with a fee for it. And these fees were not disclosed in advance. So what this bill seeks to do is say that any fee that a landlord is going to put into place has to be clearly described on the front page of the lease, so that when a tenant signs that lease, they know what to expect, they know what their monthly cost is going to be, and they know what occasional fees might be added, so that they know their full cost before they sign the lease. So that's generally what the bill does. Again, I brought legal counsel this time, and so I'm going to turn it over to Mr. Burchell to take you as a walkthrough to the bill. I want to note, and I've got some sources for you if you need to hear them. This is not just what I saw in my email and the world according to Julia. It was well documented in publications like the Las Vegas Review Journal of the reaction that happened after the last legislative session. And in the middle of a pandemic, when housing was so critical for so many, I remain very committed to making sure that tenants have the protections that they need to maintain their housing in what I think are modest, not particularly aggressive protections for tenants. I will tell you, perhaps this is not how you know when you have a good bill. Neither tenants didn't think I took it far enough last session. Landlords thought I went too far. So as always, I'm looking for the sweet spot in the middle that provides some reasonable, modest protections, because again, I believe that the tenant is in a much more vulnerable position than the landlord in these cases, and that we need to make sure that the bad actors are not taking advantage of vulnerable tenants. So with that, I'll turn it over to Mr. Berthold.
Thank you, Senator Ratty, and Chair and members of the committee. Thank you for allowing me to help Senator Ratty present today. As Senator Ratty indicated, my name is Jim Berchtold. I am the directing attorney with the Consumer Rights Project at Legal Aid Center of Southern Nevada. This is a fairly long bill, so we will just dive into it, starting with Section 1. Now, Section 1 makes no substantive change. All it does is utilize consistently definitions.
Mr. Berthold, I'm just going to interrupt real quickly because we do have an amendment. And so could you help the committee to understand if you are walking through the amendment or if you're walking through the original bill? Thank you. Julia Ratty for the record.
I apologize for that. Thank you, Senator Ratty. This is Jim Berchtold for the record. Yes, an amendment to the bill was submitted, and so hopefully everyone is working off that. That's what we will be working off today. So Section 1 simply utilizes some definitions that will be codified. Now, you'll all be pleased to hear that many of the sections simply do the same thing. So the substantive sections are not quite as intimidating as the bill initially appears. So some of the definitions that you'll see throughout are security deposit, fine, fee, and cost. You'll see repeated amendments related to those. Again, those are not substantive. It is only for consistency purposes. So let's jump down to Section 2. Now, Section 2 and Section 5, Section 3. Section 3 and Section 5. Section 2 defines cleaning deposits, and Section 5 defines security deposits. Previously, under the landlord-tenant statutes, these were combined into one statutory section, even though they are actually very separate and distinct types of things. A cleaning deposit is a non-refundable deposit that the tenant pays to the landlord. It's essentially a fee, whereas a security deposit, in theory, is 100% refundable to the tenant so long as there's no damage to the property. So those two things have been separated and now have their own statutory definitions. Section 4 defines grace period. The senator spoke about the grace period issue. This is one of the sections that gets at that issue. I'm going to skip around a little bit because I think it will make more sense, because the mechanisms to implement the changes in this bill are actually spread out in various sections. So grace period here is defined as a 3-day period during which the tenant is able to pay rent. Now, if you skip ahead to the next page, I believe it's the next page, in Section 10, we'll see that in Section 10, 3B states that a grace period, that any grace period has to be stated in the lease. So that's the second part of this mechanism. The third part of this mechanism is in Section 11. Section 11 says that no late fee can be charged until the grace period has run. So taking all those sections together, what we have is a statutory definition where a grace period is 3 days. That any grace period has to be specified in the lease agreement, and late fees cannot be charged until grace period runs. So effectively, what happens is that every lease in Nevada will require a 3-day grace period. Now, as Senator Ratty eloquently stated, why is this important? There was a huge reaction in response to the last legislative session and the change to the cap on late fees. One of the things that landlords, a subsection of landlords, as Senator Ratty said, tried to eliminate was a grace period, even when that grace period was included in the lease agreement. So this was incredibly hard for seniors, disabled individuals who receive disability payments, anyone who receives their income after the first of the month was consistently liable or eligible for a late charge. So eliminating the grace periods also potentially violated the Fair Housing Act under federal law, which requires in some instances a grace period given to tenants. So this would simply move us back to where we were and implement what is really the gold standard of a 3-day grace period. And again, that would be the floor. If a landlord wants to offer a 3 to 5 or some number in addition to the 3-day, they are certainly free to state that in their lease agreement, but at the minimum, it would be a 3-day grace period. So jumping back, let's go to Section 6. Section 6 says that a landlord cannot charge a fee for the submission of a rental application. Fees are one of the big things that this bill seeks to address, and I will talk about those in conjunction with some later sections so it will make more sense. In Section 7 relates to security deposits. In Section 7, it contemplates a procedure to try to address the security deposit before the tenant leaves the property. So the way this would work is when either landlord or tenant gives notice of the termination of the tenancy, the tenant is able to request an inspection, request that the landlord inspect the property, at which time the landlord is required to give the tenant a list of the things that the landlord believes are wrong with the property so that the tenant can then repair those things before the tenant leaves the property. Ideally, so that the whole security deposit issue can be addressed up front before the tenant's gone. Because after the tenant's gone, it just gets increasingly difficult. A tenant will receive a notice with various charges on it, and inevitably those disputes end up in court, and by that time all of the evidence is stale. So the more that we can do to address those up front, the better off everyone is, landlords and tenants. Section 9 of the bill revises slightly the definition of normal wear. Normal wear is what cannot be deducted from a security deposit. So the normal wear is the expected use, the expected wear that occurs during the tenancy. There is no substantive revision to that definition. The definition itself was somewhat antiquated and slightly confusing, so this is hopefully just providing some clarity. Now, Section 10, we really get into the fee issue. So Section 10 revises 118A.200, which is the statute that says, if there's a lease, these are the things that must be addressed in the lease. Now, under Section 3, we already addressed the grace period issue. But if you look under subsection E, what subsection E says is that any fees that are authorized by statute that the tenant has to pay have to be expressly stated in the lease. Now, that is part of the mechanism to address the fee issue. So if you look at, I believe it's on the next page, at subsection 5 also in Section 10, subsection 5 says that all fees must be disclosed to the tenant before the tenant signs the lease agreement. It also says that those fees must be displayed on the first page of the lease agreement. So that's the second part of the fee mechanism. Now, if you look ahead to Section 12, what Section 12 says is that the lease cannot say that the tenant agrees to pay any fee that is not authorized by statute. So taken together, what does that mean? That means that all the fees that the tenant has to pay have to be disclosed to the tenant in writing before the tenant signs the lease agreement. The lease agreement on the first page of that lease must say what those fees are, and any fee that is not specifically allowed by statute cannot be included in the lease agreement. In other words, what a tenant is obligated to pay is their rent and any fees allowed by law, which would primarily be late fees and a cleaning fee and some other miscellaneous fees that are provided for in the statute. Now, why is this important? In a tenant's mind, what they pay is rent. They pay X amount of dollars every month for the possession of that property. When fees vary, which some of the fees that we have been seeing do, depending on the number of units that are occupied in the premises, or when fees are implemented that have not been enforced before, tenants are thrown because that is not what they pay for rent every month, so they don't understand where those fees are coming from. For someone on a fixed income, an additional fee of $50 can break the bank. So what this means is a tenant would know from month to month that they pay rent in the amount of X dollars. Now, what does this not say? Is this saying that landlords cannot pass along their costs to tenants? No, it is absolutely not saying that. What would be required, however, is that landlords make a business decision about the costs that they wish to pass on to their tenants. They calculate those costs and they include those in the costs of rent. Now, there has been some confusion about this, about whether or not landlords would now be required under this provision to pay all the tenants' utilities. Absolutely not. Utilities are covered in separate sections of the Nevada NRS 118A. And in fact, that is one of the things that a landlord and tenant must address in the lease: who pays the utilities. And if the tenant fails to pay the utilities, that is actually good cause under the statute to evict the tenant. So that is a separate consideration. Jumping back to section 13 of the bill. All right, so section 13 of the bill really gets into the security deposit issue. Now, we've already seen that there's a mechanism in the bill for some kind of pre-termination mechanism to address the security deposit, hopefully to resolve it before termination. So this provision addresses what happens if it's not resolved pre-termination. So first, in subsection B, a cleaning deposit can only cannot exceed 50% of the base rent. Now, moving forward, what this contemplates is that a landlord can't report any amounts claimed until the landlord has actually obtained a judgment against the tenant. The landlord has 6 months to obtain that judgment. If the amount the landlord is seeking is less than the statutory limit in small claims, that case against the tenant will be brought in small claims court. If after the tenant leaves the property, the landlord actually has 21 days to provide the tenant with a written accounting, a statement of how the landlord is applying that deposit. That's actually contained in current law as well. So the landlord provides a statement and is required to return the remainder of that deposit to the tenant. If the landlord fails to return that deposit, there is now an expedited mechanism for the tenant to address that issue. So if the landlord fails to return the deposit or provide the accounting to the tenant within those 21 days, the tenant then has 30 days to file a verified complaint with the justice court and ask the court to address the deposit issue. A hearing is held on an expedited basis, and the judge can decide whether or not that deposit needs to be returned to the tenant. Additionally, we will see that in subsection 10, in any case relating to a deposit, there is a presumption that there was no damage to the property. In other words, the landlord has to affirmatively show that yes, there was damage to the property. Yes, that damage occurred during the course of that tenancy and not before. And the landlord has to actually show the actual cost of repair. Now, why is this all important? So most tenants rely on that deposit to secure additional housing. Or if they have already secured additional housing, they have struggled to come up with that new deposit and are depending on that past deposit to reimburse themselves. The current system takes way too long. Most times these disputes end up in small claims court, which can take months and months. By the time the case actually comes before the court, there's somebody else in the property and all of the evidence is stale. And it ends up being just the landlord's word against the tenant's word. So this is a mechanism to try to expedite all of that and resolve the issue for the benefit of the tenant and the landlord. Have the issue resolved so that all the parties can move on. Now, the remaining sections of the bill, sections 14 to 23, are really just revisions for consistency purposes to implement the definitions that have been included in the other portions of the bill. There is a revision that I haven't mentioned throughout the bill. There are deletions to remove the concept of a surety bond. Under current law, there is a provision that allows a tenant to obtain a surety bond to cover the deposit, security deposit. Frankly, that provision is never used and has proved to be incredibly confusing. So we recommend that it just be removed. The other provision, section 24 that I will mention, this is also cleanup from the last session. In the last section, there was a law passed that said notices of eviction that are served on the tenant have to be served by a process server, a constable, sheriff, an agent of an attorney, basically someone who is neutral, who has no interest in the outcome of that eviction. Section 24 clarifies that the person serving the notices cannot be the property manager who manages the property of which they're serving notices. And that's essentially what the bill does. I would be happy to answer any questions that anyone might have. And again, I thank you for the opportunity to help Senator Ratty present.
Thank you again, Senator Ratty. For the record, Chair, that is all of our presentation.
All right, then we will go to questions from members of the committee, starting with Senator Orenshaw.
Thank you very much, Chair Scheibel. Thank you, Senator Ratty, for bringing the bill. For Mr. Berchtold or Ms. Bortolin, you're in the trenches trying to help people who are trying to stay in their homes. And I just wondered, I've looked at some of the news articles and it's heart-wrenching reading some of them. And I just wonder if you have any clients you've represented or if there's any stories you could share with the committee about the kind of situations that your clients got into because of what's happened recently.
This is Jim Berchtold for the record. So I'm sure Bailey can chime in on this as well. But yes, thank you for the question, Senator. After the pandemic hit, our calls to our eviction hotline tripled overnight with person after person, desperate. What am I going to do? I can't work through the unemployment system. I can't get any money. So we are still talking to tenants who apply for unemployment in last March, and have not seen a dime. They are struggling, they are desperate. We actually had one of our advocates, we set up an eviction prevention hotline. One of the advocates who answers that phone to help tenants to try to walk them through the eviction process, actually was talking to a tenant the other day who was in complete distress because their neighbor had just shot themselves because the constable was coming out to the door. The caller was similarly facing eviction and so was panicked. Our advocate walked them through the eviction process, told them what steps they need to take to try to avoid the eviction, but then also gave them the number to the suicide prevention hotline. I mean, that's really where we are right now. So there's not a lot a tenant can do. There is money out there. There is a big pot of money that the tenants can access for rental assistance, but frankly, the money is moving slowly. Tenants have applied months ago and have still not seen anything. We're also seeing for some reason, a number of landlords are refusing to accept the money. They would rather see the tenant evicted than accept that money from the tenant. So where we're at, we're facing a March 31st cliff where all of the tenant protections end and evictions are going to start going forward. But yet we have $116 million of rental assistance there for the specific purpose of helping those tenants. So we are seeing story after story, and all we can really do is say, apply for rental assistance, and if you get an eviction notice, this is how you respond. So it has been an incredibly disheartening and frustrating and frankly sad experience.
And this is Bailey Bordelin representing the Nevada Coalition of Legal Service Providers. If I could add to that, I think absolutely things have been harder lately, but a lot of the issues that this bill seeks to solve are not necessarily COVID specific. We know that COVID has exacerbated the situation for a lot of people. But something that I think is fairly common for us to see, but also for the courts to see in the justice court system, is tenants who sign what they believe will be a more affordable lease. The first page of the lease will say this costs $600 a month, and they'll believe that they're signing up for a $600 lease, and the lease will be really, really long, which is why we have a lot of one document rules in other areas to try to prevent things from being hidden in those contracts, right? And so after the next month becomes due, it starts to dawn on page 17 of that lease that there were all sorts of things tacked on, and that there was $20 for the microwave and $10 for the refrigerator and $50 for the common space. And when these fees that aren't labeled as rent really add up, we've seen situations so extreme on a repeating basis that where someone thought they were paying $600 a month, they actually owe $1,100 a month. And it becomes unsustainable, which is why we end up in court before that lease can be finished through to try to figure out up from down. And so we do believe that it could bring a lot of clarity across the board to having that fixed amount on the first page of the lease so that people really understand what it is that they're entering into, and you can't hide things on page 17. I would also say on the grace period piece, we have, when people have come to legal aid, we have been able to send demand letters essentially saying under federal law, you can't be discriminating against people who receive Social Security. You've had this understanding with them. But for a lot of people that haven't reached out to our offices, we do hear that there are a lot of seniors in Nevada who have since last summer built in that 5% late fee every single month because they're never going to have an opportunity to catch up. And there are landlords who have just been able to count on that additional 5% because their tenants rely on Social Security. It's essentially become a rent increase. So the things in this bill are very limited to what we have been seeing as problems in mass.
Thank you for what you're doing to try to help our constituents stay with a roof over their head. I know it's been very frustrating as seeing people try to apply for benefits, and it hasn't been easy. So thank you for what you're doing. Thank you, Senator Ratty. Thanks, Chair.
Thank you, Senator Orenshaw. We'll go next to Senator Pickard.
And thank you, Chair Scheibel. I have more questions on this bill than we probably have time today. So I want to just ask a couple of kind of broad general questions and then get down to just a couple of details that I need some understanding. I mean, I don't have a problem with the idea of transparency in leasing. Many of you know that the first many years of my law practice was in landlord-tenant, most of which was representing tenants, although I did also represent some landlords, and I have some development experience, and I've kind of seen this from all sides now. But first, I'm wondering, I'm assuming that we're trying to help the people that have been identified, those that are kind of on the bubble financially, those that are in need of affordable housing, and those that are struggling, pandemic or not. I agree with Ms. Bordelin. I don't think this really has anything to do with, or it's not designed to deal with the pandemic. We have a bill to address DETR and all that. But with that is the understanding, who are the housing economists, those that understand the business of rentals, whether that be apartments or homes, who consulted on this bill?
I'll take that one. No one.
Okay. Let me then ask, are we trying to make it easier for people who rent to be able to afford their rent, or is this purely a transparency question?
I'll go ahead and start with that one as well. Senator Julia Ratty for the record. So I think that there's an argument that folks are trying to make that these measures will raise the cost of rent. And what we're seeing is that that cost of rent has already gone up. They're just calling it something else. So back to Ms. Borderland's example of the tenant who signs a lease that's $600, but then because of some fees on page 17 is now paying $900 or $1,000. They're paying $900 or $1,000. You can say it's fees, you can say it's rent, but at the end of the day, that landlord has built a business model that includes those fees. And so I don't believe the passage of this bill means that all of a sudden that particular unit is going to be a $900 or $1,000 unit. It already was a $900 or $1,000 unit. So really this is about the transparency. And, you know, we heard last time, and I'm not an economist, but I do spend an awful lot of time reading about housing, having done a significant amount of work in this legislature on affordable housing. And everything that I read is the number one driver of the cost of housing is market conditions. So we have seen, and I live in Northern Nevada, where market conditions are through control on a supply-demand curve. And the rent is going significantly up based not on the landlord's cost of doing business, but based on what the market allows that landlord to charge. And if there is a correction, those rental rates will go down based on what the market allows that landlord to charge. So I'm not convinced that from what we saw from the arguments on SB 151 last time, nor this bill, that this bill will do anything to inflate the cost of housing, though I've already seen the ads on my Facebook page that says that it will. I believe this will just get to transparency on where the real charges are.
And I certainly appreciate that. And given the presentation, it looks like a transparency issue. I could tell you in the years that I did landlord-tenant work, we didn't, although that was prior to 151 last session, I'd never seen a lease where they had tacked on after the fact a microwave fee and a dishwasher fee and those sorts of things. I'd never seen it. But arguably, and as Ms. Bordelin and I discussed this at some length prior to 151, many of the results after last session were foreseeable. But I want to just, because I don't want to take a lot of time, I want to talk about just a couple of the sections so that I understand them. I'm looking at, this is sub 5 of section 12. This is the requirement for small claims court. It looks like we've got a 6-month requirement. After 6 months, It must go to small claims if the amount is less than, I believe it's $15,000, or that may, no, that's the district court. I forget what the threshold is. But if it's less than the $4,000, $5,000, $6,000, whatever the threshold is for small claims, it must go to small claims. That means that there are no attorney's fees in small claims court that are recoverable. So the landlord has to cover the cost or do it themselves. Is that the intent of that bill or that section of the bill?
Mr. Berthold, if you would take that one.
So the current amount in small claims is $10,000 is the jurisdictional limit, and that.
Sorry, could we get you to put your name on the record?
I apologize, Jim
It's
Berthold
fine.
for the record. To some extent, that was the it's as simple as possible. The tenant universally is not represented in these cases, and sometimes they are the party bringing the case to try to recover that money. But part of the thought is to keep the case as simple and inexpensive as it possibly can.
Okay, but this only limits the landlord's time and ability to bring the case. This doesn't change the deadline for the tenant to bring a claim for the recovery of the security deposit, correct?
Jim Birchall for the record. Yes, I believe as written, that is correct.
Okay, so so anyway, the landlord then has to cover the cost of the attorney to collect where otherwise he would have been able to get it had this been filed in justice court. So that's going to be an added cost. Looking then at section 13 sub 6, we've got the mandatory waiver of claims after 3 weeks, and we reduced the time to return the security deposit to that same 3 weeks. Won't this induce landlords to file the claim before the expiration of their ability to obtain a judgment? Doesn't that put every tenant into a legal dispute, in whether it be small claims justice court, however much that claim is? Doesn't this require then the landlord to sue, whether or not they could otherwise work it out?
So Jim Birchall for the record. So currently under Nevada law, the way the scheme works is the landlord has 30 days to deal with that deposit. So within that 30-day period, the landlord is required to give an accounting to the tenant and to return the remainder of the deposit. And under current law, if the landlord does not do that, the landlord is potentially liable for double that deposit, damages double that deposit. So that is somewhat the way the current system already works. I mean, ideally, what will happen is within that 30-day period, all the parties will get together and try to resolve the dispute issue, and the landlord will provide the tenant with an accounting, and it can all be worked out. But will some result in a court case? Yeah, probably.
And I'm sorry, I could have probably been a little more precise. I wasn't referring to the times when a landlord hasn't returned the deposit. And those were most of my cases when I represented a tenant where they didn't get their deposits back. But in instances where this bill also requires a mandatory face-to-face between the landlord and the tenant. And I can tell you most of the time tenants won't do that. They don't want that confrontation, so they just move out. But this would preclude a landlord who cannot enter the premises without the tenant's consent at that point. It would prevent them from making a claim except within 3 weeks. So this bill limits they waive their claims, which has never been the case, is not the case under existing law. They waive their claims after 3 weeks, and then they have to also return the deposit within 3 weeks. So they have 3 weeks in which to recover or to file a complaint, or they waive their claim. So this means that if they don't resolve in the first 3 weeks everything that there is to be resolved, they must file a claim, whether it be small claims or elsewhere, in order to avoid waiving their claims. Doesn't that create a huge incentive to file a claim in every disputed case?
Jim Birchhold for the record. Thank you, Senator. So a couple of things. There is no mandatory face-to-face between the landlord and the tenant. The tenant has the option prior to the termination of requesting an inspection. And if the tenant requests that, then the landlord can expect and ideally resolve the issue up front. On the back end, the landlord doesn't have to bring a case within 3 weeks. What that is saying is within 3 weeks, the landlord has to provide an accounting of how that deposit is going to be applied. If the landlord provides that, the landlord retains their claim and then has 6 months to pursue that claim should they choose to do so.
Okay, that's a clarification I needed, because that was scary to me. I guess I don't read it that way, but I'll go back and read it again. I didn't get the amendment until just minutes before the hearing, so I apologize for that. I guess my last question I'll ask, I've got a dozen more, but it has to do with the very last section on 24, where we're talking about service, and this has to do with eviction, which is probably 90% of my practice. Where we're making it so that a landlord must hire a third party to post the notice. Can this be someone who is simply a third party contractor for the landlord? I'm thinking in the large apartment complexes where they've got 3, 4, 5 evictions every month that they've got to deal with. Are you saying, or is this bill requiring that they would go out and hire a separate process server in every case, or can they hire an independent contractor who would come in and on their behalf post the notices? I'm thinking again about the additional cost to the landlord. How does that work?
So Jim Birchhold for the record, thank you for the question, Senator. In some instances, that is already happening, and that would still continue to be allowed under this bill.
Okay.
There are third-party eviction services that are often run by an attorney, thus the agent of the attorney language, and apartments will contract with those eviction services, and those eviction services will serve those eviction notices on behalf of the landlord.
All right, thank you for that. And thank you, Madam Chair. I appreciate your indulgence. I have particularly things like proof of actual costs and those sorts of things I'm really struggling with, but I'll take the rest of them offline. Thank you, Madam Chair.
Thank you, Senator. And go ahead, Ms. Bordelin.
Bailey Bordelin for the record. I wanted to clarify on that last piece, Senator, that those changes were from last session. And so I do believe that the vast majority of landlords are complying with them. Where we've seen some confusion in the courts, and there's been some confusion amongst interpretation. And so I do think this is a clarification the judiciary will appreciate a clarification coming on. Is there was negotiated language that the agent of the attorney could be in that list. So again, everyone has found a way to adjust to the law that was changed in 2019. But there are some large bad actors who the property manager was previously serving, and that was kind of the problem that the bill sought to solve, is that there was an interested party who had an interest in saying something had been served, whether it had or hadn't, and we were seeing a lot of fraud. And so some of those properties have adjusted to just now have their attorney sign the service saying, yes, the property manager is an agent of the attorney, but no change in practice has been made. So that's not a drastic change to the statute as it exists. It's just trying to clarify that I would say it's not a real loophole, but something that's worth clarifying.
Sure, and we've seen lots of attorneys who are kind of crafty, looking for ways around things to make it easier for their clients. I get that. I tend to agree that the vast majority of landlords are good actors in this space, but certainly will, and I don't think that this bill or any bill will get rid of those that intend to try to take shortcuts. That's how people think they make money, and it just ends up costing us all more. Anyway, thank you for that, and I appreciate your responses.
Thank you, Senator.
Chair, if I may,
Please.
I want, Senator Ratty, for the record, I want to agree that this bill and no bill will get rid of bad actors. However, when a tenant seeks to resolve something in court, or in that situation, it will make a difference to that tenant. So just by passing any bill that we pass, it doesn't change people's behavior, but the remedy is important. Thank you.
Absolutely. I agree, Senator. Thank you for that. We will move next to questions from Senator Settlemyer.
Thank you. I think you can hear me. I appreciate that. I'm concerned with the bill, to say the least. I run into more and more people I know that are that have rentals that are getting out of it. And I have friends, of course, that are in rentals, and they're indicating that their landlords are telling them, it's time for them to get out. They kind of feel that they've already had a little bit more than a 3-year grace period. I mean, some bad actors, they've almost had a year grace period with the pandemic. But speaking to the actual parts of the bill, it talks about the pre-inspection period. What do you do if you have bad renters? I was in college once, and so sometimes there may have been a hole in the wall, and maybe before you left, you put a picture over it or something of that nature when you're doing an inspection. How do you deal with those type of situations? Or does the person who's doing the pre-inspection basically have the right to move all the furniture, move all the paintings, move everything around during that pre-inspection process in order to try to figure out things that may be hidden at that time?
So this is Jim Birchall for the record. So there is no waiver in conjunction with that pre-inspection period. In other words, if the tenant requests the inspection, the landlord does the inspection, provides the tenant with a list. The idea is that the tenant will repair and they'll be able to come to some agreement regarding the return of the deposit. But if after the tenant is gone, the landlord comes in and realizes that there is additional damages, there is nothing precluding the landlord from trying to recover those damages from the tenant.
Appreciate that. I think it shortens the time frame that they'll be able to, because it almost seems like it creates a rebuttal presumption that it was kind of the landlord who did those damages, or was I reading that section incorrectly?
That could potentially be the rebuttable presumption does exist in a court case, but in any court case, the landlord would have to prove that the hole was there. So I don't know that it would change the context of that court case or the outcome of that court case at all.
I think it's just a burden of proof, and I think it could be considered a little bit problematic. The other section of the bill I was looking at, it talks about you're not allowed to incur certain hard costs, like running a rental application. There's credit checks, background checks, get into the realm of, some places I remember written in college, you'd have a discussion. It's like, if you want outside parking, fine. But if you want to park in the garage, there's a garage fee. Does that preclude all those different type of contexts from happening with this bill?
So if I could jump in on this one first, Senator Julia Ratty, for the record. So it doesn't preclude that. It just suggests that should be part of your rent. So if you're renting the garage too, then make the garage part of the cost of the rent and have it be transparent and upfront as opposed to buried deeply in the lease agreement.
But that would raise the cost of the rent because, again, certain places I've been at, you were given options.
Right.
So here's the base rent, but by the way, if through the course of the time frame, you really wanted to have a covered parking for your rig because it was hot, and so now all of a sudden that comes up, and this kind of seems to preclude the concept of being able to charge that person the additional corresponding fee for the additional corresponding benefit. Or am I wrong?
Thank you, Senator Settlemyer, for the question. So if I were in that situation to rent the unit that doesn't have the covered parking, my rent would be $1,000. If I were to rent the unit that does have covered parking, my rent would be $1,050.
So in other words, you're just going to raise people's rents rather than having it be a fee.
It wouldn't
I'm
raise people's rents. It wouldn't raise the total amount. I'm sorry, Julia Ratty, for the record. It wouldn't raise the total amount that the tenant is paying. Right now, that tenant is paying that as $1,000 rent and a $50 fee. It would just be very transparent that the total cost to that tenant is $1,050. It's $1,050 whether you call it a fee or whether you call it part of the rent. But what's happening is these fees are getting hidden because they're buried, and we want people to know this is what your monthly cost is going to be.
Okay, I kind of see what you're trying to hit at. I think that when you're talking about bad actors, I could completely understand, what you're trying to do. Maybe we need to put something in the bill also to go after bad renters at the same time. So that way we're trying to actually address both bad actors, which there are bad landlords out there, and there are some bad renters. And we need to figure a way to help out in those situations too, rather than a one-sided, what I view as a more one-sided bill. But again, what about charging for going back to that question I asked, it didn't really get answered. Why shouldn't you be able to charge for a rental application?
I apologize, I missed the question on the application fee. So the other thing that we're seeing, and again, I live in Northern Nevada. I think Senator Settlemyer, you are quite familiar with what's happening with the rental market in Northern Nevada. So you have one unit, you have 50 people who are interested in that unit. A landlord at this point can charge all 50 of those folks an application fee. And 49 of those folks are never going to get that apartment. 49 of those folks are going to have to go to 1, 2, 3, 4, upwards of 10 places to try to find a unit in Northern Nevada right now. And if they have to pay $10, $50 application fees just to get on the list for an opportunity to maybe get a unit, they can't afford to do that. And so what we're asking again is that landlords build the cost of doing business into their rent, but no landlord should be able to charge somebody for an application fee for a unit that they're never going to get.
Okay, I can see where you're trying to go with that. I just get a little, because obviously if you're a landlord, you want to make sure you have the best possible person in there, and you'd want to have, the application process, which, theoretically you probably use that rental application process to cover, background checks, credit checks and things of that nature to make sure that you have the best possible person, especially in situations which I'm more familiar with in my counties where you're usually renting a house that's next to your house. So you want to try to have some renter that's going to be there for, a good tenant, it's going to be there for a long time. Someone that you become friends with over time just because of proximity, to you, and you want to try to find the best possible person in that respect. So you're trying to use this information. So, all right, well, I'll have to look at that.
Thank you, Senator Settlemyer. And I am fully in support of tenants being able to screen the person that they're going to offer the unit to. But think of a hiring process. We're going to interview 10 candidates. We're going to narrow that list down. And then when it gets to the point of offering the candidate the job, you're going to do the background check to make sure that you're not getting somebody who is not somebody you want on your team for the long haul. Same concept here. Build that cost of doing business, which should be 1, not 10, not 15 background checks, but 1 background check for each unit that you have into your cost of doing business. But what we just can't, if you're looking at it from the tenant side, many of you may have children who applied to colleges and you had to pay that $150, I don't even know what it costs now, application fee for each college. That's basically what we're doing to tenants to try to get a place to live. And this is one of the parts of the bill that I feel most passionate about, because again, in Northern Nevada right now, a tenant may need to try many, many times to get a unit because it is such a competitive market, and to have them paying a $50 fee just for the privilege of applying, it's just not acceptable.
Okay, I appreciate that. If I could follow up with a guy, and I'm sorry, I don't know your name, but section 13, as I'm reading it, it creates a rebuttable presumption that there is no damages to the premises. I'm just trying to figure out, the tenant's still living in that premises and they have exclusive control. So why is that?
Bailey Bordelin, for the record, I know you asked for Mr. Birchtold, but I'll let him follow up. I think something that was helpful for me when we talked through this was I too wanted to know how will the landlord prove, right, that there was damage. My husband's in the military, so we rent properties a lot when he's stationed other places. And recently, when we finished a lease in Colorado, they sent me the long list of reasons they weren't giving me my security deposit back. And I argued with them and walked through it. And one of them was, well, you didn't mow the backyard. And I said, the backyard was in terrible shape when we moved in. And I really believed that. And they immediately responded with a picture of the backyard, date stamped to the day before we moved in, showing that they mowed the backyard. So I assume from my conversations with some property managers that it is a common practice to document the property just by quick pictures before a tenant moves in. And that would be used to show what the state of the property was prior to the tenant moving in. But I'll let Jim add to that.
Jim Birchtold, for the record, I really have nothing to add to that. It is a rebuttable presumption, meaning that the landlord can bring in whatever evidence that they have to show that there was in fact damage to the property.
But in that respect, then the landlord has to overcome the clear and convincing standard. So why didn't you look to the other standards that are out there? What, preponderance evidence, something like that?
Bailey Bordelin, for the record, there is, in our opinion, a strong power imbalance here. And so we believe that it's appropriate because it's easy to do. It's easy to take pictures of a property, and I believe already in the best practices of going through that process, so that it's appropriate that the burden lie with the party that is better positioned to do so.
All right, I'll take my other questions offline. Chair, thank you kindly for letting me give me the freedom to ask those questions. I do very much concerned that this will just exacerbate the issue where I'm saying where sadly we're losing a lot of rental opportunities because people are just deciding to sell for the cash value. Thank you.
All right. If the record could please reflect that Majority Leader Canizaro has joined us. She joined us quite a while ago, and I have just forgotten to mention it. And we still have some questions on this bill, it looks like. We will go next to Senator Hansen.
Thanks, Chair. Actually, there is an irony that because of the political climate, especially in California, that we're seeing this massive influx into Nevada that's forcing these rents up and housing prices through the roof. So kind of a weird irony there. Like my colleague, Senator Pickard, I too have practiced a good portion of my life in the field of landlord-tenant relationships, but only being a plumber. And actually, I'm quite sympathetic to the concept of the power relationship because, the old concept of possessions is 9/10 the law. When it comes to holding the deposit, the actual cash, if you will, it gives them a significant leg up. And I, as a plumber, had to collect from a lot of these landlords. And while I met many lousy tenants, I also saw some really serious, what I would call slumlords, who were rotten human beings and did everything possible not only to cheat their tenants, but also the plumbers that came to fix the problems. And I had to go and try to collect the money. So I understand the power relationship in perhaps a different way than some of you. The transparency angle of this is great. I think that's, again, a huge thing that needs to be addressed. So I totally support that. I share the concerns of Senator Pickard and Senator Settlemyer with a lot of this, though. In some cases, the cures are often worse than the problem. The one question I had, though, that isn't directly related to the bill, but Mr. Birchtold, you brought it up, $116 million fund. I'm not familiar with that. Is that a state fund? Is that a federal fund? And what's the holdup in helping solve some of these problems for people, especially people that may be impacted by COVID?
Thank you for the question, Senator Hansen. This is Senator Ratty for the record, and I'll take the first crack at that and then ask Attorney Berthold and Attorney Bordelin to chime in. So we're talking about the federal settlement dollars, not settlement dollars, I'm sorry, stimulus dollars that have flowed into Nevada specifically to help with rental assistance. Those rental assistance programs were set up through the CARES Act and then through some of the subsequent stimulus. They were sub-managed, if you will, by different local entities. In many of the counties, those dollars are flowing out and tenants are applying for that aid. And that aid, when they are given that aid, that check is written directly to the landlord. So it doesn't go to the tenant first for the tenant to decide what to do with. It goes to the landlord. In Clark County, there has been a slower process than we had hoped for to get some of that money out. There's a significant amount of work happening right now. In Clark County, they subgranted it out to 14 separate agencies. And what they've found is that having a single portal would probably be more efficient for both tenants and landlords. And so that single portal has been developed. And I think there's some good work moving forward that you'll see some of that money flowing out more quickly.
Obviously, I'm sorry, pardon my interruption.
I think like many of the stimulus dollars that we've seen in each version of stimulus, they come with a different set of rules. And so we've had to adjust to those different sets of rules. And so I think the adjustments have been made, and I think in pretty short order, you'll see some good money flowing out. I understand the number to be significantly bigger, more in the $300 million range of money if we can work through this next precarious couple months while we hopefully are winding down the pandemic, that we get that money to tenants who need the support, which then actually goes to landlords, right? $300 million to go to landlords would be a huge economic impact for our state and for those landlords. And so I think we all are going to need to work together to make sure that that happens. Not in this bill, but since Mr. Berthold brought it up, certainly something we all need to work together on. And I will say that also landlords have been eligible to apply for the PETS program, the small business program. And so for some landlords who are of the tenant to participate in that rental assistance program, they have been eligible to apply for the small business, PETS small business loans as well.
Very good. I just was concerned when I heard that we may have another Dieter situation, so apparently you're already much more on it than I am. As honest, that's my first, I didn't even know that existed. So thank you for that. I guess the point that you brought up, Senator Raddick, and that is, look, we're gonna have lousy actors, tenants and landlords, and I don't think any bills that we can pass is gonna change the reality of human nature. However, I do agree with the concept of expanding transparency and then trying to allow people to work it out. I hate the idea that we're gonna have everybody going to court all the time. That just, it also places the tenant at a significant disadvantage. Frankly, trying to save $700 that your landlord is essentially holding unfairly. And then if you've ever gone through the small claims process, it's actually pretty efficient, but it is drug out and it's cumbersome and it can be kind of humiliating. And so let's see if we can come up with a way that we can get this resolved a little more quickly, with both parties hopefully having some opportunity to resolve it short of court. So thank you, Madam Chair.
Thank you, Senator Hansen, for the comments. And I will just add one thing, and again, not necessarily in this bill, but I do think, again, Senator Ratty, for the record, I do think that there's an important starting point that we need to have context for on this bill. I am in 100% agreement that there are bad tenants. No question about it. I am a mom and pop landlord, if you will, although I don't know how Mr. Kavanaugh, who I'm married to, would feel about being called pop. But I am one of those. I am familiar with the concept that there are bad tenants. And the thing that gives me some comfort is that Nevada is a very unusual state in that we are the only state in the nation that has summary evictions. And what that means is in the state of Nevada, as opposed to any other state, we can evict for non-payment of rent without going to court. Every other state in the union, the landlord is the one who is responsible for filing a court case to do that. So the vast majority of evictions, the vast majority of disagreements between a landlord and a tenant over the payment of rent are resolved outside of the court process. So the starting point in the state of Nevada leans heavily towards landlords, which is why I've worked pretty diligently over the last 2 sessions to try to get a few more protections in for tenants. And so I agree with you, we don't want everybody going into the courts. But when they need a remedy, as in a landlord is withholding, what is it? First and last month, and a cleaning deposit in Northern Nevada right now is a significant chunk of cash. And that's cash that in the state of Nevada, where 50% of people who live here are renting, and a very high percentage of those are rent burdened, meaning that more than 30% or more than, in many cases, 50% of their income goes to rent, they don't have an extra $3,000, $4,000 sitting around that they can move into their next apartment. So when that landlord chooses to withhold that cleaning deposit and there's no remedy, we're really talking about individuals who are homeless. So that's why this is something that I feel is important to bring forward.
Thank you, Senator Ratty. And I see that Senator Sittlemeyer has another question. If you can be brief, go ahead.
It was just a follow-up from something she just said. I've been trying to get this information for a long time. You know, the PETS program was originally supposed to be open for 2 weeks, but due to the success and need of the industries that are out there, it was only open for 48 hours. So I was just wondering if you might be able to obtain any information. What percent, because you brought it up, what percent of landlords who applied for PETS received it? Because again, there's a lot of people that applied for PETS who did not get it. You know, certain industries were categorized as more important, and they were allowed to get the PETS grant money first, and other industries had to wait. So I was just wondering if you might know that, or if you can somehow get hold of that information, because I am very curious on that point.
Okay. Thank you, Senator Sittlemeyer, for the question. Senator Ratty, for the record, I don't have that information close at hand, and as I'm sure you're very familiar because you were part of the solution, we just dumped a good chunk more money into that program. I don't know if there's anybody who's here that can answer that question at this point, but if not, we'll endeavor to get that information back to you.
Thank you.
Bailey Bordelin, for the record, if I could just add, the calculations have been difficult to do from different pots, but to broaden the scope of your question a little bit to other relief programs, while I don't have the PETS numbers, and we can certainly try to get those for you, the rental assistance pot, I believe throughout different iterations, with still hundreds of millions left, but I think we're around 496 million. I don't want to say I know that for a fact, but we're around that range. And so there's been a lot of money that way, and those checks are cut directly to landlords when the
196 million in just Nevada?
Yes. And then, and those are still available. So just, if I could, for educational purposes, because we've been trying to get the information out there, the Reno Housing Authority is doing all of the greater Washoe County area. The Rural Housing Authority is doing the rurals, and Clark County Social Services is administering Clark counties. So those pots are available. And again, the checks are cut directly to landlords. And then also I wanted to mention that the recent federal package that was just passed does include $9.9 billion in a homeowner assistance fund. So I don't off the top of my head know what the Nevada cut of that will be, but for those that the rental assistance program isn't working quite right, there is a whole nother program coming from the federal government that is again directly for homeowners, for the homeowner assistance fund. So irrelevant to the bill.
Well, since you brought that up, if you could do me a favor, could you send me those programs and also any strings that may be attached? Working with the federal government since I was about 10 years old, I tend to realize that sometimes with the federal government, they tend to have certain strings attached when they decide to give you funds, or actually let you actually use your old funds. So again, I appreciate that.
Again, Senator Ratty, for the record, I think we will be able to provide that for you for the past programs. But just as a reminder to everyone, when the recent stimulus was passed, part of the bill gave the Treasury Department 60 days to come up with guidance. So we are all anxiously awaiting to know what the strings on all of the money will be, but we don't have the details on the strings of anything just yet.
Thank you. Thank you, Chair.
Sure. Thank you, Senator Ratty. Looks like we also have another question from Senator Orenshaw. Go ahead.
Thank you very much, Chair. Thank you for the second question. And my question, I believe, would be for either of the attorneys from Legal Aid. The proposed amendment, the language that says landlords must not report alleged debt to a credit reporting agency or collection agency until a judgment is obtained against the tenant. Are you finding now with many of your clients that, this is being reported to collection agencies and credit bureaus prior to going to court to try to obtain a judgment, and that often it might have been incorrect and maybe a judgment was never sought, or that it's helping preclude that person from being able to qualify for renting somewhere else? I just wonder if either of the attorneys could talk to that.
This is Jim Birchtold for the record. Thank you for the question, Senator. Yes, we are seeing that frequently. Oftentimes when a tenant leaves the property, the way they learn that the landlord thinks they owe money is because they go to apply for another place, or they get a collection agency calling them, or they pull a credit report and see that there's a tag on their credit report. And this has gone through no verification process at all. Those numbers are simply numbers that the landlord is saying, this is what I believe the tenant owes. So I'm going to report that to the collection agency, or I'm going to report that to the credit reporting agency. That can be hugely problematic for tenants in a number of ways, as it would be for any of us who found out that there was something negative on our credit report. And unfortunately, the remedy for that is very problematic. The tenant can file a dispute with the credit reporting agency and say, I disagree with this. But all the credit reporting agency does is go back to the landlord and say, is this correct? And the landlord will say yes, and it remains on the credit report. So there is really no affirmative way for the tenant to remove that from the credit report. In fact, we have seen tenants where they will affirmatively sue for their deposit simply to get something in front of the court, so that the landlord will hopefully bring a counterclaim to resolve the dispute about what money is potentially owed. And there has to be a better way than that.
I appreciate the answer, so that there might be less litigation with if this is in the statutes. That was what you're saying. Thank you. Thank you, Chair.
Sure, thank you. Any other questions from members of the committee? All right, not seeing any questions, we will now move to testimony in support of SB 218.
Thank you, Chair Scheibel. To testify in support on Senate Bill 218, please press *9 now to take your place in the queue. Once again, to provide support testimony for SB 218, please press *9 now to take your place in the queue. Caller with the last 3 digits, 821. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, committee. My name is Shane Piccinini, SHANE, I manage government relations for the Food Bank of Northern Nevada. And for a long list of reasons that are too detailed to go in here, I just wanted to say that the Food Bank of Northern Nevada supports the work of this bill. Almost all of our clients are going to be impacted in a positive way by the outcome of this bill. And we appreciate the hard work that Senator Ratty has put in trying to improve the affordable housing situation in Nevada. Thank you.
Thank you, caller. Caller with the last three digits, 419. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair Scheibel and members of the committee. For the record, my name is Benjamin Chalnar, and I serve as the Policy Director for Faith in Action Nevada. I am here to speak in support of Senator Ratty's Senate Bill 218, as it looks to fix the severe imbalance of power between tenants and landlords. One piece of advice that I was given in college as I was applying for off-campus housing was to not expect your security deposit back because you will never receive it. I unfortunately took that as a truth. The actual truth is more concerning. 40% of Nevadans are renters, and of those, 2/3 are people of color, and oftentimes they are low-income renters or on a fixed income. Many of these renters often have every penny accounted for and find it difficult to come up with a new security deposit. They rely on the previously held security deposit to find their next home. When the tenant provides the security deposit, they enter in a good faith agreement with the landlord or property manager that they will return the security deposit after they return the property in good condition. Here at Faith in Action Nevada, we have heard from members of the community that they never were returned their security deposit, even after taking care of the property and cleaning it upon vacating. The reasons often given to them were ranging from a cleaning charge to painting or replacing a carpet, even though there wasn't any damage. It will now be on the landlord to prove that this damage was beyond normal wear and tear and that it was actually caused by the tenant. Senate Bill 218 also looks to tackle predatory fees and rental agreements and clearly state any. We have also heard from the community that they have additional fees that are often hard to keep track of. By seeing it on page 1 how much they owe each month, both in rent and justified fees, it will make it clear how much in total is owed and allow for tenants to properly budget for their housing. Lastly, we would like to thank Senator Ratty for SB 218, and we urge the passage and implementation of this bill. Thank you for your time.
Thank you, caller. And as a reminder for any who's just joined us, we are currently on support testimony for Senate Bill 218. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 777. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Ben Innes. That is BENINESS. And I'm a social work intern with the Progressive Leadership Alliance of Nevada, here in support of Senate Bill 218. First, we're going to thank Senator Ratty for bringing forward this important piece of legislation to help Nevada renters. SB 218 works to level the power imbalance between landlords and tenants. By clearly defining terms, limiting and preventing fees, and offering tenants larger windows of time to operate in will allow renters to maintain safe and stable housing. This is extremely important, as we know the safest place for COVID-19 is in your own home. Without these measures, the process can be arduous to navigate and also feel punitive at times with high late fees and obscure deposits that can easily be stripped from you and not reimbursed. In fact, recent research by Matthew Desmond and Nathan Wilmers has shown that landlords disproportionately generate more profit from poor neighborhoods when compared to middle-class and affluent neighborhoods. And by supporting SB 218, we can work towards undoing that disparity. Thank you.
Thank you, caller. Caller with the last three digits, 601. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Committee Chair Scheibel and committee members. My name is Barbara Paulson, BARBARAPAULSEN, and I'm speaking on behalf of Nevada's for the common good. All of us need to have some level of certainty regarding our monthly expenses, especially those major and most costly ones. And for many individuals and families, not only is housing their single largest monthly expense, but they're living on a very close margin between their income and expenses. And even a small change in what that monthly total is can be devastating for them. Nevada for the Common Good supports Bill SB 212, Senate Bill 218, and we strongly urge that you pass it because it will provide greater certainty and security in their monthly housing obligations for thousands of Nevada residents. Thank you for your time.
Thank you, caller. Caller with the last three digits, 540, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. Excuse me. My name is Serena Evans, spelled SERENA-EVANS, and I'm the Policy Specialist for the Nevada Coalition to End Domestic and Sexual Violence, and we're here today in support of Senate Bill 218. For victim survivors, having access to safe housing is one of their most urgent needs. Many victim survivors throughout the state are feeling the impacts of the pandemic, the co-occurring housing crisis, and as well, majority of them are recovering from financial abuse from their perpetrator. These victim survivors often search for a long time before they find housing that they are comfortable in, let alone that they can afford, and oftentimes a previous security deposit is relied on to be able to obtain their new housing. It is imperative that landlords provide full transparency of the lease that tenants are entering into so that the tenant can calculate the true cost. It is predatory for landlords to create spontaneous fines and to withhold security deposits for undisclosed reasons. We urge you to pass Senate Bill 218 to help protect Nevada families and victim survivors. Thank you so much.
Thank you, caller. Caller with the last three digits, 663. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you all very much for your time. My name is Bo Jones. I'm the owner-broker for BDJ Realty, and I speak on behalf of 100 different landlords here that don't necessarily live in Nevada, but own property here in Nevada. And I'm hearing one person after the other standing and opposing, for this bill for all of the people that live out there. But landlords most often are the victims. They're the ones that are putting their house out on the line and hoping that somebody will leave it in as good or better condition when they go. Making laws harder and more strict on owners and property managers, I feel, is the wrong direction. Pardon me?
I'm sorry, is this testimony in support of the bill?
No, I'm opposed to it.
Okay. There will be an opportunity for you to call in to voice your opinion later during the hearing, but right now we are taking testimony in support of SB 218. Next caller,
I'm
please.
sorry. I thought I was supposed to log in after 1.
Thank you, Chair Scheibel. Apologies for that. Caller with the last three digits, 912. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, my name is Emily Montan, M-O-N-T-A-N, and I am a citizen of the state of Nevada. I live in Reno. I'm also active in my church at the Unitarian Universalist Fellowship of Northern Nevada, which is part of Faith in Action Nevada. I am calling this. First of all, I want to thank Chair Scheibel and Senator Ratty for this bill, and I want to tell you that I support SB 218 for the two principles in my faith. One is the use of the democratic process in society at large, and provide justice for all, which is another one of our principles. And I have lived in 4 different state jurisdictions, and none of them have summary evictions. The landlords are making buku bucks. I know people who own property, and making the due process fair or equal for tenants is not going to cost them that much. They make plenty of money, and the market has driven the rates, the rentals way high. So it's not going to be an undue burden. And they somehow manage, because I used to rent, I am now a landowner. I own up my property. I used to rent up until I was about 55 years old. And I can tell you that most most landlords are good actors and most renters are good actors. But the ones that are bad actors, we need a fair, transparent due process for everybody, both sides of the fence. And right now, it's heavily in favor with the summary evictions for the landlords. It is not in favor. And everybody else who's spoken in favor of this bill has said the reasons why we need to make renting possible for our growing population, because I have seen that dramatic increase of homeless people, do a lot of volunteer work with them, and it's mostly due to rent. They're all looking for safe, most of them are looking for safe, secure, affordable places to rent and not get evicted for unknown reasons. So this bill will go in a long way. And anybody who says that it's going to cost the landlords a lot of money, they're still making plenty of money, and they can add it in the cost of doing business. There's tax deductions, everything else for them, whereas renters do not have significant tax deductions. And I urge you all to push this bill forward and pass it. Thank you very much.
Thank you, caller. And as a brief reminder, we are currently on support testimony for Senate Bill 218. If you'd like to provide support testimony and have just joined us, please press *9 now to take your place in the queue. Caller with the last three digits, 016. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, and thank you for hearing this bill. For the record, my name is Wesley Ewell. That's Wesley. Last name is Juhl, and I'm the Director of Communications and Outreach for the ACLU of Nevada. We support SB 218 because we believe that housing justice and racial and economic justice are all connected. That's why the ACLU of Nevada is a member of the Nevada Housing Justice Alliance. Nevada renters are experiencing more hardship than ever before, and the legislature can and must act to give them some relief. Retaliatory and predatory fines and fees, things like light bulb fees and microwave fees, have no place in equitable housing policies. We like that SB 218 will ban these fees and add clarity for tenants so they know exactly what their expenses will be each month. Me personally, I especially love the parts of this proposal related to security deposits. I'll tell you, I've been a renter in Nevada for much of my adult life and still am, and I've never once had a deposit returned to me. And my home is like a sacred space to me. I'm not the type at all to trash the place by any means. Clarifying the reasonable wear and tear language can help thousands of Nevadans like me. We're in the midst of an unprecedented housing and economic crisis. Please pass SB 218 and continue to consider measures to protect tenants and bring some semblance of housing justice to the state of Nevada. Thank you.
Thank you, caller. Caller with the last three digits, 548. Please press *6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
My name is Shannon Thompson, ShanNonThompson. I'm in strong support of this bill because there are some good landlords out there, actually a lot of good landlords out there. Like anybody on this planet, situations happen that make people look at other people differently. But all it is, you have to sit back and put trust in people in this day and age, because of when COVID-19 happened, my landlords and the owner of the property supported me 100%. And I'm going to support them 100% because they're not bad people. Thank you very much.
Thank you, caller. Caller with the last three digits, 714. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Senators, and thank you for allowing me to speak today. And for the record, I'm speaking in support of SB 218. My name is Robin Franklin, Franklin, with Now Nevada, the national chapter. I'm speaking to you on behalf of those women and children who are negatively impacted by low or little regulations to fee schedules that landlords are able to assess. I have a sister who has 5 children who is in low-income housing, and she recently left an apartment. Upon leaving, they charged her over $2,000 in fees, basically having her to refurbish this apartment that she's lived in for over 5 years. These charges are paying for the carpet, the weather stripping, for the refrigerator, and the stove, just to name a few. All of these things were used repeatedly by her within the last 5 years and is not being considered as normal wear and tear. It's preposterous to think that a person with low income or no income will be able to pay $2,000 for an apartment that should be refurbished by the landlord themselves. They have these fees placed on their credit, preventing them or making it even harder for them to have housing, creating an even greater chance for them to be homeless or having housing insecurity. And because of that fact, they can't afford to get it off of their credit. I say this today that it needs to change. We have women and children who are suffering from housing instability, and because of that, they sometimes have to see me in my professional capacity as I work in child welfare. Ultimately, they're at risk of being separated. Too many days I've seen families standing on the street with all of their worldly possessions. I see those families who do not have a place to live and who cannot get a place to live because of the above circumstances. Landlords have been given free rein to do this, and given the fact that it's not clearly or fairly regulated. You good senators have the ability to change this at the source.
Right now? So if you could wrap up.
Sorry, thanks. Okay, so I just ask that, stop the abuse, the tendency to be protected. Thank you.
Thank you, caller. And if you've recently joined us, we are currently on support testimony for Senate Bill 218. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 656. Please press star 6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, good afternoon. For the record, Will Pregman with Battleborn Progress, WILL, P as in Peter, REGMAN. We rise in support of SB 218. This is yet another bill that protects tenants who have been under unique stresses throughout this pandemic. And before that, this bill gives certainty to renters on how much they can expect to pay each month. It shields them from surprise fees and unreasonable grace periods on payments, and ensures their security deposits are returned in a timely manner. That last piece is essential to help renters secure their new housing upon leaving the property to move forward with their lives. While landlords certainly have an interest in receiving payments on time, the same courtesy must be afforded to the renter. This bill helps balance this relationship, keeps the payment structure predictable, and encourages better relationships between tenants and their landlord. As so many Nevadans who rent have struggled to make their payments over this past year, we should see it as imperative to help renters have stable, affordable shelter. Thank you, Senator Ratty, for bringing this bill, and we encourage the committee to pass it. Thank you.
Thank you, caller. Caller with the last 3 digits, 199. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. My name is Tess Opferman. That's spelled OPFERMAN, speaking on behalf of the Nevada Women's Lobby. One of the top priorities of the Women's Lobby is housing security. We work hard to support legislation that ensures women and families are able to maintain affordable and stable housing, something made even more difficult by the current pandemic and the incredibly high rates of unemployment that has disproportionately affected women and women of color. We want to thank Senator Ratty for her hard work on affordable housing and for bringing this bill forward. This bill, addressing lease agreements, hidden fees, rental applications, and cleaning deposits, is critical to protecting tenants and holding accountable bad actor landlords. We urge your support on this bill, and we thank you for your time this afternoon.
Thank you, caller. Caller with the last 3 digits, 166. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chairwoman Scheibel and members of the committee. For the record, I am Mary Janet Ramos, Maryjanet. RAMOS, and I'm representing the Culinary Workers Union, Local 226. The COVID-19 pandemic has hit culinary union members and their families incredibly hard. While hospitality workers are slowly returning to work, tens of thousands of workers are still unemployed and struggling with housing insecurity. Since last March, the Culinary Union has worked with our Housing Fund and other organizations to keep workers in their homes. Unfortunately, there's still too many Nevadans who have lost their home during this pandemic. SB 218 addresses retaliatory and predatory behavior that has been on the rise in Nevada's rental market in the last year, ensuring that renters get back their security deposits back in a timely fashion, requiring that any fees owed are cleared to the renter, and instituting grace periods for rent will help keep tens of thousands of culinary union members in their apartments. In the middle of this pandemic, working families and people of color have been disproportionately impacted by housing insecurity, and SB 218 is a step in the right direction towards rectifying that. The Culinary Union believes that every Nevadan deserves to be treated with dignity and that housing is a human right. Nevadans should not have to decide between having food on the table or a roof over their head. The Culinary Union urges you to pass and support SB 218. Thank you.
Thank you, caller. Caller with the last three digits, 254. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
My name is Kristen Berzamato, KristenBurzumato. I'm in support of this bill. Large reason why is the rental market is very tight, and what I am running into with trying to assist my niece, who's a school teacher in her 30s and extremely financially responsible, is that every rental that comes available will still take an application fee from you, even though they've had 50 applicants. And I believe one of the representatives earlier brought that up. There's no reason for that. You are not going to rent that to 50 people. And look at the amount of money that they're making just by taking application fees and misleading people to think that they've got a chance. Maybe part of this is going to be rectified by that, because a person can very easily, because they're stressed and see a rental that's available, apply for 5 or 6 different places at a time, hoping one of them will take them, and they've lost all that money. That's all I have to say, and thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give support testimony at this time.
All right, thank you so much. At this point, we're going to go into a very, very brief recess, and we will return at the call of the chair. It will truly just be a few moments. All of our members with us right now? you all could give me a little sign that you're here. Thank you, Senator Settlemeyer. Thank you, Senator Hansen. And so today we have 5 BDRs that you all received via email. You may have also received written copies since this morning. I'm going to take them all at the same time and ask if there are any questions on any of the BDRs from anybody. And if there are no questions, I would entertain a motion to introduce these BDRs. As always, introduction of a BDR is not the same as approving of the bill or asking that we pass the bill. It is simply the mechanism to allow us to have those bills drafted and introduced on the Senate floor. I do see a question or a hand from Senator Pickard. Go ahead.
Thank you, Madam Chair. I'm just looking at 1008, and we've got an exception to the interception of wired communications, and it appears that this is excluding certain law enforcement activities. And I'm wondering, have we prevented, because of 200-620, have we, NRS 200-620, have we prevented the interception of these calls? I thought these were routinely intercepted because in an emergency situation, law enforcement, I thought, was allowed to intercept these things and then obtain a warrant retroactively. But maybe because I don't practice in this area, I'm mistaken.
I appreciate the question that you're asking. That sounds like a policy question that we could definitely dive into in a hearing. Right now, these were questions about introduction of the bill.
I was just trying to understand what it is, Madam Chair.
And I'm not sure that I can answer that question on the record right now. Senator Orenshaw.
Chair, if you're open for a motion, I move introduction of the 5 bill draft requests.
And just to clarify, Senator Orenshaw, that is BDR 16-499, BDR S-501, BDR 14-830, BDR 40-1006, and BDR 10-1008. Is that correct?
Yes, Chair.
All right. Is there a second? And we have a second from Vice Chair Cannizzaro. Would the Secretary please call the roll?
Senator Cannizzaro.
Yes.
Senator Orenshaw.
Yes.
Senator Settlemeyer.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
No.
Chair Scheibel.
Yes. And with that, the motion carries to introduce these 5 BDRs that I just read out on the record. I appreciate everybody taking the time to do that. And we can now return to the hearing on SB 218. So reopening the hearing on SB 218. We had heard testimony from those in support of SB 218. Our fantastic staff at Broadcast has informed me that there's nobody else on the line, or there was nobody else on the line in the support position at the time that we took our recess. So that leads us now to testimony in the opposition position. Please go ahead. Everybody will have 2 minutes to speak, and I would like to remind you that that is a maximum, not a minimum. You can certainly simply indicate on the record that you agree with previous caller or sentiments that have already been expressed. Mr. Kyle, please go ahead and queue up opposition testimony.
Thank you, Chair Scheibel. To testify in opposition at this time on Senate Bill 218, please press *9 now to take your place in the queue. Once again, to provide opposition testimony on SB 218, please press star 9 now to take your place in the queue. And caller with the last 3 digits, 448. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. My name is Tiffany Banks, spelled Tiffanybanks, and I am General Counsel for the Nevada Realtors. I'm speaking today on behalf of the more than 18,000 members of the Nevada Realtors. I would like to thank Senator Ratty for speaking with us on the bill and asking us to get our concerns on the record today. We are opposed to nearly every section of the bill and the proposed amendment submitted by Legal Aid. This bill will only harm Nevada's families, and if passed, SB 218 could have dangerous consequences on their ability to find sustainable housing. I will only discuss a few of the sections in my testimony today. We oppose Section 7 of the amendment, allowing a tenant to request the landlord to conduct an initial inspection up to 2 weeks before move-out. This request is not really a request, as it becomes mandatory on the landlord to comply. It would be impossible for some landlords to comply with this time frame if the landlord lives out of town, if the landlord or property manager schedule does not match up with the availability of the tenant. Only after a full and thorough evaluation of the property can a final assessment be made as to whether or not tenant's damage exists that will be charged to the tenant deposit. Landlord cannot see what stains are being covered up with rugs, what holes are in the walls that exist under the pictures, and what damage will be done on move-out or before during the 2-week period between the initial inspection and move-out. It is far worse for the tenant to expect to get something back and then fail to because of their own actions. One of the most concerning sections of the amendment is Section 13, where the landlord must provide proof of actual costs incurred by the landlord to repair the damage, or 3 written repair estimates if the damage has not yet been repaired. Vendors are difficult to schedule, especially if the repair is a small but necessary repair. Vendors may be reluctant to spend the time to provide an estimate for a small repair job for which they may not be compensated. This will leave the landlord with no remedies for repair. If a vendor does charge for an estimate for repair, this cost will be paid by the deposit, leaving less deposit available for the tenant. For example, if there's an issue with a garbage disposal and 3 plumbers charge $80 each for 3 estimates, that would be $240 when the cost for repair is only $200. A total cost of $440 for a repair that is less than half that cost. These estimates may be charged to the security deposit, meaning that not only would the tenant be out the cost of the repair, but also the cost of estimates. Please consider the terrible impact these regulations can have on affordable housing and Nevada's families.
Thank you, caller. And as a brief reminder, if you've recently joined us, we're currently on opposition testimony for Senate Bill 218. If you'd like to provide opposition testimony at this time, please press star 9
Madam
now.
Chair, can I ask the realtors a question?
We don't generally allow questions during the public testimony portion of the hearing. I would ask that you follow up with them offline.
So where do I ask opposition questions then?
You can follow up with them offline. I can provide their contact information if you don't know how to get in touch with them.
Once again, to provide opposition testimony on Senate Bill 218 at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 911. Please press star 6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Thank you, Chair Scheibel, and members of the Senate Judiciary Committee. My name is Maggie O'Flaherty, and I am here representing the Manufactured Home Community Owners Association. My name is spelled Maggie, O''F as in Frank, LAHERTY. This bill presents several problems for our members already struggling 1 year into an eviction moratorium. SB 218 undoubtedly places undue burdens on landlords in a time that many are struggling just to stay above water. Removing our ability to charge a fee for rental applications does not eliminate the cost to process the application. It only shifts the burden of cost from the applicant to the landlord, which could then result in landlords passing those fees back on to tenants. Our members pay hundreds of dollars monthly to process background checks for applications before accounting for printing or employee time. And similarly, charging a fee for a bounce check is very common sense for landlords. Not only do our banks charge our members a fee if a check bounces, but without a fee, there would be nothing to deter tenants from writing faulty checks and would eventually force landlords into not accepting checks altogether. We additionally have several concerns with Section 13 of the bill. As practiced, we already offer tenants the chance to remedy deficiencies and make necessary repairs, but more often than not, we can't see the actual extent of the damages to a unit until the final walkthrough when the unit is completely empty. In some instances, tenants conceal damage, and as drafted, landlords would be on the hook for damage that would never be discoverable during a walkthrough. Furthermore, an inspection 2 weeks prior to move-out limits our ability to see the actual extent of damages if something happened during those 2 weeks. And in the same token, the provisions limiting cleaning fees to 15% of periodic rent offers us little to no room to make the necessary repairs we see in vacated homes. Our rentals typically fall under $900 per month, and 15% of that would only leave us with $135 to make necessary repairs. We've seen a mass exodus of landlords leaving the state as a result of some of the burdensome policies that have made the cost of doing business in the state of Nevada just too much to bear. And this will only continue if we continue to present similar kinds of undue hardship onto landlords. I appreciate you hearing our testimony, and that is it.
Thank you. Caller? Caller with the last 3 digits, 711. Please press star 6 to unmute. Once again, caller with the last 3 digits, 711. Please press star 6 to unmute yourself. One more time, caller with the last 3 digits, 711. If you can hear me, please press star 6 to unmute. And we will move on. Caller with the last 3 digits, 500. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good afternoon, Madam Chair and members of the Judiciary Committee. For the record, Dan Morgan, that's DAN-MORGAN, and I am the CEO of the Builders Association of Northern Nevada. The Builders Association represents home and multifamily builders and developers throughout Northern Nevada and engages on issues of concern to the home building industry. The multifamily rental market is an important part of the home affordability equation throughout Nevada. The Builders Association consistently advocates for policies that encourage residential construction in a manner that does not increase the price of housing. SB 218, like several other landlord-tenant bills being considered by the legislature this session, makes it less attractive and practical for builders and developers to become landlords. We are very concerned that these type of policies will depress the construction market for multifamily homes and rental properties, exacerbating the already high home prices by limiting the supply of available units. We urge the committee to reject SB 218 and allow the multifamily construction industry to thrive. Thank you for the opportunity to speak to you today and very much appreciate your service to our state.
Thank you, caller. Caller with the last 3 digits, 662. Please press star 6 to unmute your mic. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair Scheibel, the committee, and Senator Ratty. Susie Vasquez. For the record, I am the Executive Director of the Nevada State Apartment Association, and we represent 67% of all multifamily housing in the state of Nevada. Since the pandemic has been mentioned, landlords continue to be asked to bear the burden of this crisis. SB 218 and the amendment presented today will only make the bleeding worse for landlords and, in turn, tenants. First, application fees allow us to recover costs we incur to obtain screening information.
Fraud is very prevalent, and a thorough screening takes time and also protects not only the landlord, but those who may be a victim of fraud as well. It would make more sense to codify only one application is allowed per unit until the unit is rented, which falls in line with best practices of our industry. Second, I want to note the length of our lease directly correlates with the language requirements of existing statute, which provides the tenant with a written record of protections afforded to them, as well as provides a clear record of what fees are due on a monthly basis. Terms of a lease are not allowed to be charged or changed on a whim. Next, the amendment imposes a 24-hour turnaround time, which for a landlord to present an itemized list of deficiencies after an inspection. This timeline is overly burdensome. We echo the concerns already mentioned by the realtors related to the inspection, and rebuttable presumption have already been discussed during this hearing. Finally, I do want to note that it is not the standard practice for the apartment industry to charge first and last for a security deposit. However, as more and more restrictions which mimic that of surrounding states are imposed on my members, the likelihood of that standard practice coming to Nevada increases. SB 218 will drive many of our good landlords to leave the market, reducing the overall supply of rentals, as well as further discouraging those that provide affordable housing to remain in the program, further driving up housing costs for the tenant that this bill purportedly is supposed to protect. Thank you.
Thank you, caller. Caller with the last three digits, 232. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair and members of the committee. For the record, my name is David Dazlich, spelled D-A-Z-L-I-C-H. I'm the Director of Government Affairs for the Vegas Chamber, here today testifying in opposition to SB 218. As you've heard from the realtors and others, this bill has numerous provisions which would make it more difficult to be involved in the rental of property in the state of Nevada. Unfortunately, this will cause shrinkage in the rental market, as well as increased market rate rents across the board. As we attempt to rebuild our economy after the pandemic, we must consider the availability and affordability of market rate housing as necessary for economic growth. We urge you to vote against SB 218 and keep Nevada housing affordable and available. Thank you.
Thank you, caller. Caller with the last three digits, 663. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Yes, my name is Bo Jones. That's Big B, little o, last name Jones. I am a broker, property manager, as well as a landlord here in town. I represent about 100 owners that I have worked for in the last year. I am opposed. Apologize for my breakthrough earlier. I missed that section. Wanted to just stand and let you guys know that I have a ton of my investors that are leaving Las Vegas. I manage in Las Vegas, North Las Vegas, and Henderson, and they are bailing out. I'm not against having stronger rules. I think landlords should be held accountable, but when you tie our hands so tight that we can't follow the rules, that's when things get broken. We have to count on vendors, and we have to work on vendor schedules to be able to come out and give us a bid. 21 days is my biggest concern for what you all are working on right now. We have to get vendors out. A lot of our owners want more than one bid. That means we have to get multiple vendors out. Tenants' ideas as well as are different than landlords as to how a property should be left. My brokerage specifically states how we want the property left, what our cleaning guidelines are. They are signed at the beginning of the lease. We send a copy of that out to them as soon as we get a 30-day notice, and we're very fair and very open. I'm kind of shocked to hear about all of the landlords out there that are not following these rules, although I should I should know about it. I get a ton of tenants that are unhappy from previous. But if you force all of us landlords and the property managers to go to court for an eviction, it's going to tie our time and increase, I mean, a lot of money for our landlords. It's not just a matter of scheduling a court date. They get moved, they get canceled. It's just the summer eviction is the best way to go, and I'm trying desperately to keep landlords here in Las Vegas, the city that I know and love, for our tenants that are out there. Thank you for your time.
Thank you, caller. And if you've recently joined us, we're currently on opposition testimony for Senate Bill 218. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 983. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. My name is Teresa McKee, Teresa-McKee, and I'm CEO of the Nevada Realtors. I'm speaking today on behalf of more than 18,000 members of Nevada Realtors. We are opposed to nearly every section of the bill, and we thank Senator Ratty for speaking with us about this bill and allowing us to get some of our concerns on the record. We oppose Section 6. Charging a fee for a rental application is necessary to cover out-of-pocket expenses for tenant screening. If a landlord is not able to charge those fees to prospective tenants, it will be added to the cost of the rent. We oppose Section 7. In reality, only after a full and thorough evaluation of the property can a final assessment be made as to whether or not the tenant damages exist that will be charged to the tenant deposit. If repairs are not completed in a workmanlike manner, the landlord will have to have those re-repaired by a professional, and the landlord should not be required to accept a tenant's less than professional repair topic. We oppose Section 4. A late fee amount should compensate the landlord for the inconvenience and risk of not receiving rent on time and should motivate the tenant to pay rent on time. Contractually agreed upon provisions should not be further limited or amended. We oppose Section 13, prohibiting a landlord from charging a cleaning deposit that exceeds 15% of the periodic rent. Not all properties are equal and not all tenants are equal. 15% is a randomly chosen level of recovery that is not realistic or fair to property owners. Further, in Section 13, we oppose requiring the return of the remainder of the security deposit within 21 days after the end of tenancy. It would create a huge burden on the landlord, the courts, the working class handymen, journeymen, and contractors. In many markets, it's simply impossible to retain professional services and have the work completed within that time. And remember, until that property is repaired, the landlord is also suffering the loss of the rental income on that unit. It is in their interest as well to get those repairs done quickly. Please consider what these provisions could do to Nevada families and the affordable rental market when landlords sell their properties. Thank you.
Thank you, caller. And caller with the last 3 digits, 711. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Chair Scheibel and members of the committee, good afternoon. My name is Terry Moore. That's Terrymoore. I'm an attorney that practices in landlord-tenant law here in Nevada, and I primarily represent landlords and property managers who manage and own approximately 25,000 apartments and single-family homes throughout the state. As a practicing landlord-tenant attorney, on a daily basis, I'm in the trenches, as Senator Pickard mentioned. And on a daily basis, I deal with many, if not all, of the aspects of NRS Chapter 118A that Section SB 218 seeks to modify. These are not modest changes to Nevada law, as Senator Ratty suggested. These are, realistically speaking, many of SB 218's proposed revisions will cause havoc when they're actually applied to real-world landlord-tenant situations. Most of the proposed revisions actually appear to be solutions that are looking for problems. I've handled evictions in nearly every county in this state, and I can unequivocally tell you that justices of the peace that hear and handle evictions every day fairly and competently resolve nearly every issue that is being addressed by SB 218. That is why my clients and I oppose nearly every aspect of SB 218. Nobody's opposed to transparency. Transparency is good, but this bill goes far beyond that. Section 13 of the amendment, shortening the time frame from 30 days to 21 days for the landlord to provide the tenant's security deposit accounting, is not only unreasonable, it's unrealistic. In many instances, damage to a unit needs to be repaired by an outside vendor, and that can take weeks to even get scheduled, let alone completed. If the damage is extensive and the vendor can't get it done, under Section 13's language, the amendment automatically penalizes a landlord by making them liable to repay the entire security deposit, even if there is extensive damage, and it forces the landlord to waive any claims relating to that damage. Under no set of circumstances is such a draconian penalty fair or warranted under Nevada law. If a dispute arises over a security deposit, much like the one Senator Ratty indicated her former neighbors had, there's a remedy already in place. They file a motion in front of the Justice Court, and it's resolved. And the judge is allowed to weigh the evidence, hear the testimony, and make a fair ruling. There is no need to implement new procedures and new mechanisms to overly complicate that process. Additionally, the Section 13 proposed change of adding in a rebuttable presumption and imposing an incredibly high burden of proof on the landlord is a radical change to Nevada law. Under that proposed language, there's an issue with limiting it to damage caused only by the tenant, which is a problem. But it also inserts this rebuttable presumption that there was no damage to the premises at all, and then it imposes the incredibly high burden of proof that's equal to the same burden of proof a landlord.
I'm sorry to bother you. We're at 2 minutes per speaker. Thank you for your testimony and whatever else you can send in writing to the committee. Thank you, sir. Broadcasting?
It is in writing. Thank you.
Oh, thank you, sir.
Thank you, Senator Orenshaw. And with that, there are no more callers to give opposition testimony at this time.
Thank you very much, Broadcasting. Is there anyone who wishes to testify on Senate Bill 218 in the neutral position?
Thank you, Senator. To testify in neutral standing on SB 218, please press star 9 now to take your place in the queue.
Thank you. And that will be 2 minutes per speaker.
Thank you, sir. Once again, to provide neutral testimony on SB 218, please press star 9 now to take your place in the queue. And at this time, Senator, there are no callers to give neutral testimony.
Thank you very much, Broadcasting. Senator Ratty, thank you for being here and presenting the legislation. Any closing remarks you or Ms. Bortolan, Mr. Bergtold would like to make?
Sorry, I just continue to have technology problems this week. I apologize.
No worries.
Thank you, Vice Chair Orenshaw. I very much, again, appreciate the opportunity to be in front of the Senate Committee on the Judiciary. Long hearing, I know that this is a contentious issue. I will say that it's been a long, hard year. I know we're just a year past the kickoff of the pandemic. And I just want to acknowledge that there has been more than enough pain to go around, and that pain has hit tenants and that pain has hit landlords. So I just want to be clear that I'm not blind to that fact. I still think that there is a significant power differential when we're talking about, even when the impacts to a landlord are significant, it's not as significant as losing the roof over your head. And so I think we have to figure out a balanced approach to making sure tenants have a remedy when landlords are taking advantage of the situation, frankly. And so I think, again, that these are reasonable and modest protections for tenants. They are modest compared to protections that you see in most states across the nation. I don't believe that this legislation significantly raises the cost of housing in the state of Nevada. That was the testimony to SB 151 last session, and we did not see a crumbling of the rental infrastructure because of the modest protections that were put in last session, and I don't believe we will this session. I do believe some tenants or some landlords are going to get out of the business, but I don't think it's because of these tenant protections. I think market forces have a lot to do with it. Their property values are up significantly, and I do think some folks are fatigued based on the pandemic and some of the things that have happened because of the pandemic. But I don't think it's because of modest protections that we put in place to equalize the balance between tenants and landlords. So I think there's still some work to do on this bill. I'm open to doing it, and I very much appreciate your time in hearing this bill, your questions, and I seek to make sure that your questions get answered. Thanks so much.
Thank you very much for your presentation. Thank you for all your hard work, Senator Ratty. We'll now close the hearing on Senate Bill 218. And the last item on the agenda is public comment. Broadcasting, if there's anyone on the line who wishes to make public comment, that is 2 minutes per speaker.
Thank you, Senator Orenshaw. If you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. Once again, to give public comment this afternoon, please press star 9 now to take your place in the queue. And Senator, the phone lines are open and working. However, there are no callers to give public comment at this time.
All right, well, thank you very much, Broadcasting. Thank you, members, for your attention to this bill. Thanks to Senator Ratty. Chair Scheibel had to step out. I believe Judiciary is meeting again tomorrow at 1 p.m. and we're adjourned.